Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. And he picked the card up and read it. I was expecting he easily walked up or sat down, not that he was stupid enough to actually read something out. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long drawn out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior the couple decided to get back together. And instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. I'm a public defender in an area with lots of MUs. M makes most people talk a lot. So I can't tell you how many clients forget to mention that they got to the jail still high and called their mom girlfriend buddy on the recorded jail phone and not only confessed to the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. I'm seeing this question a lot, so I'll add some info here. This is not legal advice, just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded. Depending on the facility, calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. I heard of a guy trying to appeal his disability benefit being revoked. He was supposedly a paraplegic, but the opposition had over 10 minutes of video footage of him walking, running and even jumping over a fence. After the 1 minute mark, the judge said, "Okay, I've seen enough. Please leave." Credit card theft fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, "Because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him." The jury convicted him and I learned that day to better prepare my clients for trial. There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the back seat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question, "Was there anyone else in the backseat of the vehicle?" It was a Hail Mary. Even when there are multiple arrests, Police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have feasibly been in the backseat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and, shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the backseat, there was more than enough reasonable doubt. Proofs were concluded and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact no matter how obvious it may seem. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial, and the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along thrown. And the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty, so yeah, I was completely dumbfounded. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial a pen rolled off the table and she is bending over trying to reach it from her chair, but pen was too far away. So she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay and her response was that she was fine. Her attorney leaned over and said something to her and she then loudly started complaining about her back and how much her back hurt, but no one believed her, lol. And it's not even my stories but my dad's. He was working as a fraud investigator for an insurance company. I have a few stories of his but here's two of them. Guy was claiming theft of multiple items but mainly a ring. Things weren't adding up so my dad and the insurance company's lawyer decided to do a depo of him. Guy shows up and is doing the depo when my dad notices the guy is wearing the exact ring he's claiming was stolen. My dad slides a note to the lawyer telling him the guy's wearing the ring. Once the note got slid the guy realized what happened and put his hands under the table and took the ring off. They asked him to stand up and lo and behold the ring fell to the ground. Another one is a guy claiming a break-in and theft. Immediately things weren't adding up as the window was broken out instead of in. The guy submitted Polaroids of items he claimed were his like TVs and such. Thing is in the Polaroids you could see the reflection of the store they were in on the glass. He also claimed numerous CDs records but oddly enough every single one started with an R, S, or a T. We're talking hundreds of CDs records. My dad was about to deny the claim in person but noticed he had a gun on the table so decided to do it over the phone. Ready for an escalation? Later the same guy was arrested for beheading a prostitute and throwing her head in the river. That went from 0 to life in a heartbeat. This one ended my marriage. Well, it was the start of the end of marriage. My husband lost his job in the title mortgage business, applied for unemployment, got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, is there anything you did that caused them fire you? He says no, absolutely not, they fired him out of nowhere. Hearing day comes. He testifies under oath that he did nothing wrong, was a good employee, no issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings. Documents he forged and backdated. Had to admit he perjured himself. Needless to say he didn't get unemployment and he didn't sleep at home that night. Not my case, which is a gift from above, really. civil trial before a jury for injuries and prop damage from a MVA, and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly, first for the deposition and then for trial testimony, with the standard questions. Were there any prior incidents, arrests, convictions, anything that can be used to impeach any of DUI's testimony, yada yada. Over hours, denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel, DC, puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damages. It goes well. Then plaintiff's counsel, PA, gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA, earlier, you testified that this was a one-time mistake and you've learned your lesson. Is that correct? DUI, yes. PA, isn't it true that you've already been convicted of DUI in another state? DUI sits silent as DC immediately objects, but it's properly overruled and DUI must answer. Since what happens next is impeachment, I'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun, and just as rapidly overruled. DUI, yes. PA, and isn't it true that, in your prior DUI, a child died? You can imagine what's happening in the courtroom and, most importantly, amongst the jury. And you think it's over. Stick a fork in DUI. It's done. But then, PA goes for the jugular. Do you remember the name of that little child that you killed while you were driving while intoxicated? Imo. This question is one for the ages. More powerful than the old "when did you stop beating your wife?" Because no matter how you answer, and that is why you never, ever lie to your attorney. I had a client who, despite being a large man, had been domestically abused by his much smaller wife throughout their marriage. After the divorce, she turned her anger on their son. He ran away one day to live with his dad, and we filed to restrict her parenting time and for a permanent modification. At the permanent hearing, she denied being abusive to the child or my client in front of the child, said she never threatened anyone ever, and that she never made disparaging remarks about my client in front of their son. What she didn't know, and therefore hadn't told her attorney, is that he had recorded multiple instances of her abuse. So I called my client back up for rebuttal and played an audio recording of her screaming at my client, threatening to break his face in, and calling him a loser, all while the child could be heard in the background begging her to stop. I looked over at the other attorney and she had her face in her hands. We won. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that that is absolutely not true. On the stand, during his portion of testimony, my mentor asks, at any point in the marriage, did you lay your hands on your wife? One time we were having an argument and I held her down on the couch until she stopped arguing with me. What? My mentor said it was like she could see it happening in slow motion and all the alarm bells were going off in her head because he had never mentioned this, and apparently, to him, this was not abuse. The judge gave wife a lot more money as a result and husband was baffled. My mentor was fuming. ETA. Husband admitted this was the only time he had laid hands on wife. My mentor was more peeved because she had thought the case was in the bag since wife had abandoned the kids with husband to run off with her lover down in Florida and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community, hence why she was so dang shocked at his answer. But your honor, I wasn't using my hands. I was about to complete a land transaction which required my client to have built a road. Indeed, the entire point of the transfer was the road. My client, as I call him prior to completion, turns out I didn't build the road. I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on contingency once he obtained the verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.50 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200K because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates got $8K apiece for 2 years of work. Years ago, I had a client charged with drunk in public. It's a minor infraction, but he was on probation, so he needed to fight it. He told me he was very drunk that night, but had made it to the lobby of his brother's apartment and was waiting for him to come down to get him upstairs. I take this information and run with it, bringing photos of the apartment complex in the bylaws to court. My goal was to prove that the lobby of the apartment was secured to guests and residents only, which would arguably take the drunkenness out of being in public. There is no formal discovery for minor infractions in my state, since there isn't a real option for a plea deal on the minor charge, and wanting to ambush the officer with my argument, I do not discuss the case with him and we go to trial. The wheels came off the wagon when the officer testified that he encountered my client at an apartment building on the other side of the city. He was outside at the call box, not even in the lobby of this different building, rambling AMD, barely able to stand. I'm whispering to my client about this reversal and he slumps over and says something to the effect of, "Sorry, I meant to go to my brother's apartment. Maybe that's why he couldn't find me." And he sounded angry on that phone. Cross-examination was not fruitful. It was basically, "Officer, are you really sure it happened where you said it did and not at this other apartment building miles away?" Closing argument. That he wasn't that drunk also didn't get us anywhere. In the end, there was a fast guilty finding, a minor fine, wasted ink and paper from printing useless exhibits, and light sanctions later on the probation violation. I would have used the Ole Ron White defense. I wasn't drunk in public until they threw me out of the bar and into the public. I'm still a law student and this happened during my first internship at a court. A girl among other people was charged with drug possession, but because she had thrown away the drugs and the police couldn't prove that she bought or owned the drugs, BC, it could have been one of the other people as well who still had drugs on them. Full stop. The judge ruled in dubio pro reo. He then asked if she wants to add something and this girl asked if she can get her drugs back. The defense attorney looked like he was about to get a heart attack. For those wondering, I know what in dubio pro reo means, but I wasn't sure if they use the term in other countries and tried to explain it if not. This happened in Germany. I really don't want to believe anyone is that stupid. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason? He organized via Craigslist to have someone collect a box of his CM from a children's playground. There were explicit messages from him asking what they did with it, and whether they rubbed it all over themselves. The employer provided us the messages. He was doing this on company time. I was actually on a jury. Guy was suing a business. Said he got injured. Couldn't work for 3 years. Defense counsel: "Sir, isn't it true that you spent 18 of those months in prison for armed robbery?" Guy was saying he was shopping at a major grocery store chain and slipped in some water on the ground in front of a freezer. Guy has cell phone video his wife made of him in the water, and we could hear her saying that the water wasn't showing up on video and to splash it with his hand so it would look better in the video. It also came out that he'd had 3 prior convictions for crimes of dishonesty. That may not be the exact term, but something similar, for things like shoplifting and other petty crimes. Second edit for more info while I'm on my lunch break. Guy was representing himself pro se. Defense counsel asked him if his inability to work could be from the 2 previous knee injuries he'd had. When asked how they knew about those injuries, he was told his previous lawyer had given the defense's medical records upon request. Guy wanted to enter his MRIs as evidence, but had no one there as an expert witness to explain to the jury what they showed. He wanted to show us what the results were. Reminds me of a lucky guy who slipped on PP at the Costco. Not mine, but went to court over a ticket. Lady was in front of me for DUI and hit and run. The judge assigns a lawyer for her since she was so shook she quit her job. The judge asked the prosecuting attorney for details on the case. She legit says, "You mean that car I hit while I was intoxicated?" The judge stops, takes his glasses off and says, "Everything is recorded in this courtroom. I told you not to talk to anyone about your case except the attorney that I assigned for you." You could tell he was ready to walk out of the room with the level of stupidity this lady showed. UK not a lawyer as such, but a planning consultant. Client signed sworn affidavit stating he'd been running a truck park business for over 10 years on a piece of land. After 10 years the use becomes immune from legal action. The counsel checked Google Maps and saw immediately he lied. Had only ran the business for 7 years. He had committed a criminal offense by submitting a false sworn affidavit. Plonker. Sounds like something typical of owners of truck parks, etc. My dad was for many years involved in ensuring these kind of people waste disposal firms etc operate in compliance with environmental law. He had no end of tales about how impossible they were to work with, even when they weren't in the wrong. It's a shady field of business. When I was an intern at court, I was watching a battery trial with another intern. The defendant was asked if he can remember how many people were present when he beat up the other guy. He then points at my fellow intern and says rather loudly, "She was there but she didn't see anything. Don't trust her." Of course she wasn't there and the defendant was found guilty. A defendant was written a cell phone ticket while driving and defended himself. "Your Honor, I was not using a smartphone while driving. I was actually using a flip phone." Guilty. Unfair dismissal case. The client claimed to have been dismissed without reason or following procedure. After we had started the case, it comes out that not only was he given 3 written warnings, but he was also called in for a disciplinary hearing before his dismissal. Don't lie to your lawyer. Similar to a doctor, I feel like not telling your lawyer everything can just hurt you. Not a lawyer, but going to law school. I worked for a defense attorney who did a lot of federal work. One of our cases was with this guy charged with flesh trafficking of minors. We met him at the prison to interview him and he swore up and down he had nothing to do with this and that he didn't even know the girls. A month or so later, heaps of evidence from the US Attorney's Office comes in and it's pages of Snapchat messages and texts between him and these girls, video confessions from every co-defendant and victim saying our guy was the ringleader, proof of him checking in out of different motel rooms, etc. We showed him the evidence and he claimed his co-defendants were conspiring against him. He continued to deny everything and wanted to go to trial, but we repeatedly told him that would not be wise because of all the evidence against him. He ended up requesting a new attorney to be appointed, claiming that we were ineffective. To this day my old boss and I reminisce about how difficult this client was when we catch up on the phone. Estate matter. Client neglected to tell me he had 4 children from a previous marriage. Guess who showed up to challenge the will after he died? They lost, but I would have drafted his will differently had I known. Not a lawyer, but a woman I know received several hefty speeding fines. In my country you can go see a magistrate to have the fines reduced if you plead poverty. She heard about this and decided to give it a shot. So she went to court and told the magistrate a sob story about not having enough money. The magistrate heard her out. Then he asked her, "Madam, what type of car do you drive?" She replied in a tiny voice, "A Porsche." Anyone saying that a Porsche doesn't necessarily cost that much and isn't indicative of her financial status. So I'll add that it was not a beat up or old model at the time. She could have paid the fines without breaking the bank. She was just pushing her luck. She's a wealthy woman who just didn't want to pay her fines and the magistrate wasn't having any of it. Not a lawyer, but was in court to testify on another case. Accused is pleading guilty and judge tells him to allocute and describe the crime. After the defendant gives a detailed confession, the judge glances at the paperwork and says, "Mr. So-and-so, that's not what you are accused of." The guy groans and says, "Oh, that's the other county." If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.